Morning, everyone. We're going to get started in a few minutes, so just hang tight. Feel free to put your video off if you don't want to be on the screen, and we'll get started in a few minutes. Okay, Mike, I think we can get started as guests are continuing to come in.
Good. Okay.
All right.
Well, welcome, everybody. Good morning. My name is Michael Weiler. I'm the senior counsel at Kane Shannon Weiler. I am joined this morning by my partner, Chris Drinovz, who is the partner of the firm and the head of our employment and labor group. And we advise, as noted, a number of areas that may affect your business. Kane Shannon Weiler just celebrated its 50th year as the now largest law firm south of the Fraser. I joined Kane Shannon Weiler, my brother's firm, in 2019 for two reasons. First of all, I wanted to work with Chris and build the practice. And so it's been a good relationship for both of us. But the other one was the NDP got in 2018. And I know from my many years of experience that once the NDP gets in, from a business point of view, it's not necessarily that good for things like labor legislation, et cetera. So my 40 years of dealing with this stuff puts me in good position to anticipate the type of changes that unfortunately have been brought in and more are coming. So that's the interest. So a couple of weeks ago, a week ago, Ian Tossenson, who's the president of the BC Restaurant and Food Association, spoke to the Langley Chamber, and Chris and I attended. It was fortuitous because of this webinar we're putting on. And we just learned a lot about the industry. Ian took us through sort of pre-COVID, COVID, and then how your industry is trying to come out of COVID. One of the things that struck Chris and I was that pre-COVID, you had 200,000 people in your industry. It's down to probably 185,000 people today. So that's a big issue. That's a drop of 15,000 people, which goes to the labor shortage. But it also makes you a target for unionization, because at 185,000 employees, they could make a lot of money in union dues. So that's part of the reason that you may want to think about why this is an important webinar. Ian prepared a menu which went through and outlined what their organization was doing and all of the kind of hurdles that small businesses, and especially the fast food industry and small retailers, go through. And we've sent that out. We won't go through it, but it's a useful reminder that it's a very expensive area for any business in BC. So if we can assist at all in this webinar, avoiding any problems with unions, it's just another item off your plate. Because if you are unionized, it's a cost item. So that's what we're hoping to do this morning. Try to enlighten you about the unionization process under the Labor Relations Code, so that you can kind of immunize your organization. And also, we want to give you a dry run of what it would be like if you get that phone call on a Friday afternoon saying, "Hi, I'm Alice from the Labor Relations Board. We have an application for certification. There'll be a hearing next week. So this way you'll understand the process a lot faster and be able to respond. BC has, the urgency is that the fast food and small retail industry has a target on your back with the unions. Certifications have increased since 2019 by 40%. So those are changes to the labor code that we'll talk about. One of the things that got Chris and I thinking this may be an appropriate group to speak to was when we heard that the A&W and Kamloops, the first one across Canada, was unionized. And that should be a wake-up call. Amazon is in the process, as you know, of a huge organizing drive in Canada. They just, the union lost, but only because the company found a bunch of extra employees to balloon the unit. Starbucks continues to make headlines, as we'll talk about a bit, at the union. So further changes are also coming that we want to chat about in 2024, 2025. So here's the agenda. Quickly, we're going to talk about what does it mean to be certified, being unionized? What does it mean? I'm also going to give you a brief history of the labor code because that's important. Also, then we're going to talk, Chris is going to talk about the critical steps in the certification process. You move fast and you have to know what the rules are so that you can instruct your lawyer to make whatever submissions you can make in a very short order. We'll talk about documents like the investigating officer's report, what happens at the labor board hearing that Chris will talk to you about. Then I'm going to talk about the type of things that we raise potentially as defenses to the union's application. And then Chris is going to take you through a very recent case involving Starbucks, sort of like what could possibly go wrong with unionization. But it'll give you an idea of the type of unfair labor practice complaints that can arise and you want to avoid. I'm going to talk along with Chris about some of the, not all of them, but some of the things you may want to think about why your employees may choose not to unionize. Just sort of practical advice that we can offer that gives you some idea. The next thing is we're going to talk about the Section 3 2024 Labor Review Code panel that has been struck. They are right in the middle of preparing a report. That report will generate legislation. And if it's the NDP are in come the fall, we can imagine it'll be mostly in favor of unions. So that's what we want to talk about. And the key thing is the focus on the demands by union for sectoral bargaining in the fast food and small retail area. So then if we have questions, time for questions, please send a note with your questions. If we don't get to all the questions by 11:30, Chris and I will respond individually to any questions you have as best we can. So a couple of caveats. Lawyers like rules. First of all, we can't provide legal advice. Each case is different. We can give you a template of what to look at. Questions are so important. So don't be shy about asking what you may think is a dumb question. I've won some of the better cases I've had because my client asked a stupid question. I said, jeepers, I never thought about that. And we find a way to find a solution. I suggest you keep the materials confidential and keep everything confidential. The less union organizers know about what you're doing, the better. And then we provided with your registration some resource material that I won't go through. But one of the things you may want to look at is the LRB website, which is quite good in providing information. But you can't take it to the bank. There's a recent case where employees relied on what was on the LRB website. And they said, well, how can you change the rules? And the labor board said, yeah, well, we tell you that you can't rely on the labor board website, so we're not going to take that into account. But it does give you a pretty good idea of the process, okay? So what does it mean to be unionized? Most of you would have a pretty good idea of it. But what it means is you're bound and covered by the Labor Relations Code, which is a statute. And it has regulations and rules that govern the process upon which a union can apply to the labor board to be unionized. Now, in the non-union setting, which I assume and hope most of you are and remain, in the non-union setting, The relationship between you and your employees is an individual contractual relationship. That's the nature of the relationship. So you have the right now to negotiate terms and conditions of employment with each employee. They don't have to be all the same. However, if the Labor Relations Board certifies a union to be the exclusive bargaining agent for all of the employees in, quote, the appropriate unit, then that ability to negotiate terms and conditions of employment is removed. You're dealing with the union, okay? Now, because you can no longer negotiate terms and conditions of employment individually, obviously you deal with the employees, but the relationship has been fundamentally altered. What will happen then is that the union will negotiate or try to negotiate a collective agreement, and the collective agreement will then cover the terms and conditions of employment, not the individual employment agreements. So employers have to negotiate in good faith, Section 11 of the Labor Code. So once a union's certified, little things happen, like terms and conditions of employment are frozen and stay frozen for 12 months or until you get a collective agreement, whichever occurs first. There are numerous provisions under the Labor Code that protect the right of unions to organize, and they're called unfair labor practices, Section 6 and 8. Chris will look at some of those for you, but they're sort of like areas where employers, you hear about a union, you say, oh my God, we better fire the guy who's bringing in the union. That's not a good move. That's the type of constraint you have. But again, we'll review that. The certification, it's often described as, it's sort of like the marriage certificate, and the collective agreement is like the actual marriage. What happens is the collective agreement tends to replace the certification. The certification just simply gives the union the right to move towards a collective agreement. So it's the collective agreement that becomes the nature of the relationship in being unionized. The code covers strikes and lockouts. If you're not able to negotiate a collective agreement, there are very strict rules on what you can do to replace workers during a strike, which is dangerous. And Section 55 is a provision that allows the Labor Board effectively to impose a first collective agreement through a mediated process. Okay, so I'm going to just spend a few minutes talking about the history, and that's not just because I'm old. It's because it's important to, as I tell people, you only look back for the purpose of looking forward. And this is very apropos when you're dealing with the Labor Code. And I'll tell you why. So back in 1992, many of you will recall, the NDP got into power. And what they did was they struck a 3-person panel to review the Labor Code and make recommendations. And my recollection is 40 out of 44 changes favored unions. I remember my junior associate doing an article for our newsletter at that time regarding those changes. But here's the critical things that you need to know. In 1992, they got rid of the secret ballot vote, which would allow all the employees to decide in the secret ballot vote if they want to be unionized. So they got rid of it and said, if you sign up more than 55% of the people, you are automatically certified. That's critical. They also very much limited employer free speech. So if you step over the line, you can commit an unfair labor practice. And then they introduced this replacement worker restrictions in Section 68. They also appointed Stan Lanyon as the first NDP chair of the Labor Relations Board, and that was very significant. Stan passed away recently, just a great guy, and all of us like Stan, but Stan came from the operating engineers, Local 115. He was the in-house counsel, and he became the chair, and he issued a number of very important decisions, not necessarily in favor of employers, dealing with certifications. And the one that we're going to talk about is called IML, Island Medical Labs. That's the critical case that sets out the rules, basically, on how a union will get unionized for your employees. So that was not a gift from Stan. One of the recommendations in 1992 that the NDP did not accept was sectoral bargaining, which would cover certification for an entire sector. And here's I went back and looked at the report from 92, and guess what one of the examples they gave of what would be a really good sectoral bargaining unit was employees working in fast food outlets in Burnaby. So if that doesn't sort of ring a bell, now you dodged a bullet in 1992, and sectoral bargaining did not get in, but it's on the horizon now. So what happened is in 1992 to 2002, my practice soared and union certifications soared. And that's just the nature of the beast, okay? Then in 2002, the Liberals were elected, Liberals as they then were known. And when they gained power, I remember being part of a group of business leaders that looked and worked with Campbell and his group about what type of changes were critical. And we kept hammering the drum. You got to get back to the secret ballot vote. And sure enough, that's what happened. Also, we encouraged the government then to expand free speech. An employer should be able to talk about its business and pros and cons of unions and such. So we felt that was important because at the end of the day, the labor code is not about unions. It's not about employers. It's about employees. And so informed votes we thought were really important. So guess what? Union certifications during that period declined substantially. Now, I don't want any tears for me and Chris. All the other areas, human rights, employment standards, wrongful dismissal, they filled the void quite nicely. But generally, labor union issues became less important, okay? What's also interesting is in the 90s, there were a huge number of certifications of Starbucks, for example. And some of the cases that you go back and look at relate to Starbucks. You all recall the Starbucks various cases in Vancouver. So guess what? 2018, as I say, NDP's in, they're back. Guess what? They set up another panel to look at changes. And again, they introduced a number of changes in 2019. The vast majority were in favor of unions. And so things like restricting free speech. They set us back to 1992, the exact language from 1992 they brought in. They allowed unions to get remedial certification, even if they can't sign up people, if an employer commits an unfair labor practice. They shortened the time to appear at a hearing at the labor board to 5 business days. That's critical. They extended the life of a union membership card from 90 days to 6 months. All of that helped unions build their membership. The thing that they didn't do was they didn't abolish the secret ballot vote. And that's not because they had an epiphany and said, jeepers, that would be nice to have a democratic process. It's because the Green Party had a deal, as we all remember. And the Green Party said, no. If you're going to be unionized, put in these other protections, but at least keep the secret ballot vote. So that's what they did. And I can tell you from experience, I think, again, unions don't do as well when there's a secret ballot vote, okay? So 2022, we all remember how we voted in that election. And the Green Party and the agreement, the governance agreement was eliminated. And what else was eliminated shortly thereafter was the secret ballot vote. So game on. And I remember the minister coming across with a very strong argument. He felt that, really employees, when they sign a card, that's the first vote. And then what we were doing in a secret ballot vote was just having a second vote. So let's just get rid of the second vote. That's the nature of what we have. I challenged that in my blog, but it didn't make any difference. As Chris pointed out to me in the Labor Board annual report, the number of certifications has gone up dramatically, right? So that's the nature of the beast. And so with that in mind, Chris is going to take you through the process. And what's really important, you're not going to be experts on this stuff. I mean, I've been doing it a long time and I'm not an expert. So, but what you're going to do is a dry run. You're just going to be able to say, jeepers, I don't have to be totally advised by my lawyer or professional advisor of the whole process when we're trying to get ready for a hearing in 5 days. So Chris, over to you.
Awesome. Thanks, Mike. Hi, everyone. I'm so glad you joined us here this morning for this webinar. I'll just reintroduce myself. I'm Chris Drinovz, and I'm a partner with Mike in our employment group, and I head up the team here at KSW Lawyers. So now that Mike's kind of set the table with the background and the history lesson, I'm going to get into some of the nuts and bolts of the certification process itself. You know, how does it work? What can you expect if you're being organized by a union? So as you can see in the slide there, the first step in the process is the union needs to sign up the employees with membership cards. So we typically see this done either by a representative of the union that starts meeting with the employees after work hours in secret, or you may have a pro-union employee that starts talking to the employees and, you know, spreading the word about union membership. And ultimately, the goal is to have the employees sign a union membership card. The regulation to the Labor Relations Code sets out some rules about how the cards work. The employee can join by signing the card. The card must be dated and signed by the employee, and it must contain a very specific statement where the employee acknowledges that the union is applying to be certified, to be their exclusive bargaining agent, and to represent the employee in collective bargaining. As Mike said, that's the purpose of the union. Interestingly, it used to be that you had to sign a physical card and hand that into the union, and that would be the membership evidence. Nowadays, with technology and digital advancements, they can have electronic cards. And so what we have seen recently in some organizing campaigns is the union will have a flyer or something, and there'll be a QR code on the card, on the flyer. And you just have to scan the QR code with your phone. It takes you to a signing page, and then you just click sign, and then it inserts your signature, and then that card goes back to the union, and they've got a member. So, you can do that much easier. You don't have to physically be given the card by the union organizer. These things can be transmitted and delivered to the union much easier than it used to be. And you're not even having to physically sign your signature anymore. You're just clicking a button and all of a sudden, you've signed. And we've had some cases where, after the fact, employees have said, I had no idea what that was. I just clicked the button because my coworker said to do it. Once a card is signed, it's valid for 6 months. So it can be used as evidence of union membership for a 6-month period prior to a certification application. And as Mike said, it used to be 90 days. That was now doubled to 6 months. So the union has basically, half a year to get things together for its organizing campaign. An employee can revoke their membership in the union, but of course it's not as simple as it is to sign up. So in order to revoke, again, there's rules governing that, and you have to sign a clear statement revoking your membership, and you have to send that not only to the union but to the labor board. So it's a bit more of a formalized process. And interestingly, the revocation is only effective up to midnight on the day that the union applies for certification. So if anyone tries to revoke after that, i.e. on the actual day, then the revocation will be invalid and they'll still be considered to be members for the purposes of counting up support. So once the union's done its organizing and gathered up enough cards, they believe they have enough support through the signed cards, and they will file an application to the labor board. So there's a specific form that they file, and that goes into the labor board registry, gets processed, and this is where things start to happen really quickly. Labor board gets the application, and then pretty much immediately they'll send out a notice to the employer. That's sent by fax, and the board will usually follow it up with a phone call as well, and they'll use the information they have on the certification application to communicate that information to the employer. We've included a copy of the materials that the Labor Board sends in your packages. And I'll just bring that up now, actually. So this is essentially what the package looks like. So there'll be a notice to employer indicating that an application was filed on a certain date. It was filed by the union. The union will be named, and then the employer name will be in there. And then there'll be a description of the bargaining unit. And Mike will talk about how important that is in a moment here. So bullet point 1 basically says, here's the package. There's an employee notice and certification process poster that comes with package. And the board says you have to immediately post this at your location in a conspicuous location so the employees can see it. And you also have to email it to all of your employees that are in the proposed bargaining unit, so both to their work email and to their personal email. So the idea is that the board really wants the employees to get this information package so they understand what's going on. I'll show you what it looks like. So this is the poster that you would post in your workplace, and this is the notice to employees that would be posted. So that has to be done immediately. The next thing that the board talks about is the mandatory survey. So it says within 24 hours of receiving the notice, you must complete and file the mandatory employer survey and email a copy back to the Labor Board officer. So the survey is essentially a list of all of the employees that are in the proposed bargaining unit. They have a spreadsheet that they ask you to fill out, which has all the names, the job details and the hire date and other information about the employees. And within that survey, you also have to identify employees that would not fall within the bargaining unit because they're, for example, management employees, or they may be otherwise excluded from the union. So even from the very beginning, there's things you need to do that could have a serious impact on the outcome of the application, because the way you fill out that form and the positions you take regarding who should be in and who should be out is relevant and important. So within 24 hours, you need to have advice and know what you're doing with respect to this survey. Once you've completed the survey and submitted it in, the Labor Board officer will complete what's called an officer's report. And that's based on the data that the Labor Board has from the union in terms of the membership and the data that it gets from the employer in terms of the employer survey. In the process of preparing that report, the Labor Board officer has a number of powers. So they can audit the union's membership cards, for example, to make sure that all of the cards are legitimate, that indeed, Mr. X who signed up actually wanted to sign up. They also have the power to audit the employer. So if they feel that the list given by the employer is not correct, they can conduct a payroll audit to make sure that they get all the information they need. So there's a process of collection of information, and then this report gets produced to all the parties and to the Labor Board. And the report will give a summary of the information, which again is very important and useful for preparing for the hearing. Bullet point 6 of the notice says the board will conduct a hearing into this application within 5 business days of it being filed. So that's what we talked about, things moving incredibly fast. They've gathered all this information and there's a hearing. And so basically the second page of the notice will give you a video conference link. The Labor Board does all the certification hearings by Zoom, and that's the date and time for the hearing. You've got to show up, regardless of how you feel about the union or what's been going on. You've got to be there to give your position. At the hearing, and actually one comment on the 5 days. We have seen the unions get very tactical on this, and because they know the timeline is so short, it used to be 10, it's now 5. the union will file the application on 4 p.m., often on a Friday before a long weekend. And so the clock starts ticking as soon as they've filed it, and getting it in on the week before means the hearing is going to happen the following week on the Wednesday or the Thursday. So again, there's no time to lose on these things, and by the time you get it and figure out what it is, you may have only 1 or 2 days before this hearing starts.
Chris, can I just interrupt one thing? When I said they got rid of the secret ballot vote, that's in most of the cases. But if a union signs up 45% and less than 55% in an appropriate bargaining unit, they still will proceed with the application for certification. But in those circumstances, there'll be a vote. You can imagine that unions aren't necessarily wanting to file for a vote. So they often wait till they can sign up and get over that threshold 55%. And so most of the issues being fought at the hearing, which happens, as Chris says quickly, are on the premise that they have more than 55% signed up. And you will know that, Chris will take you through the IRO report, but you'll know that as you're going in, arguably, where they are. That's right.
That's right. Yeah. And so in essence, if the labor board is satisfied that at least 55% of the employees within an appropriate bargaining unit have been signed up, then that union is automatically certified. And as Mike said, there's no vote. Everything goes based on the cards. If the support is between 45 and 55, then in that instance, there will be a vote ordered. So if the officer's report indicates that that's the threshold level of support, then it will go to a vote. And as Mike said, union doesn't want that situation, and so they probably won't even be applying unless they have the 55. But if you can use some strategies in terms of who's in and who's out and who's excluded to lower that level down below the 55%, then you could at least get a chance for a vote where you have some more options and potential to have the employees convey their wishes in a much more democratic way. If the support turns out to be less than 45%, then the application is dismissed.
One of the things in the IRO report that we've sent you a copy of, just so you can get an idea, is that if they at least get the threshold, they get a list of employees. They don't get their contact information, but they get a list of employees. And so, but as Chris says, if there's less than 45, the IRO will not provide that list. And so they can't kind of use it. Now, that's one of the major changes the unions want. And just one other point, as I think of it, because of electronic communications, et cetera, and signups, you got to be really careful with your confidential information, even beyond London Drugs. You got to be careful to keep your employees' email information and phone numbers confidential, because you don't want the union to be sitting there with a list of all your employees, and then the organizing becomes a lot easier if it's in that regard. So just 2 points on that I wanted to note. Thanks.
Yeah, great points. So the hearing is the opportunity for the employer to make objections and to raise legal issues with the certification process, whether it's by raising an unfair labor practice that I'll talk about in a minute, or by making submissions on the appropriateness of the bargaining unit, which Mike will talk about shortly as well. So if you can successfully make an objection to say, we think there's been an unfairness here because the union's done X, Y, Z, or we think the group of employees that the union's going for is not an appropriate bargaining unit, you may be able to put the process on hold, and the labor board will say, okay, we need to look into this with some more detail. We're going to have a formal hearing, or I want to have written submissions from the parties within the next week, or we're going to set down a more formal process where people need to give evidence and be cross-examined. So getting to that hearing and kind of having a game plan and knowing what objections you're going to make is key, because that might give you an opportunity to do a deeper dive into what's happened with the organizing campaign and all that kind of stuff. Again, another reason why it's good to get legal advice sooner rather than later. Another big thing that comes up, and Mike's referenced already, is unfair labor practices. This could be its own webinar topic, so I'm just going to flag a few things quickly so you've heard it. Basically, an unfair labor practice is any conduct that interferes with the employee's freedom to decide whether to support a union or not. And these types of practices are prohibited by the labor code, and there's a whole slew of them. They're particularly important during the organizing and certification process, because the union can use an unfair labor practice, if proven, as grounds to ask the labor board for what's called remedial certification. And remedial certification means that the bargaining unit can be certified even if the union doesn't have the threshold support, either the 45 or the 55% support. So the unfair labor practice can get you a union even if the employees haven't signed up 55%. So what is not allowed? I'd encourage everyone to read section 6, 8, and 9 of the labor code. It's not heavy reading. It's just a really good summary of the different unfair labor practices. Employer can't interfere in the administration of the union's business. An employer can't discriminate against an employee because they support the union. So if you know that there's an employee that's a union organizer or a union supporter, you can't fire them because of that. You can't discipline them because of that. You can't demote them or change their conditions of employment in a negative way because of that. You can't promise a benefit to an employee if they agree not to join the union. You can't make a term in your employment contract that the employee will not join the union. All of those things would be considered unfair labor practices. Most important one during organizing is that once the union starts organizing, the employer cannot terminate or discipline any employee unless they have proper cause for doing that. And proper cause, of course, is a term that gets argued and litigated, but essentially it means a good practical business reason for doing what you're doing that is unrelated to the organizing and the union drive. So if you were planning to, if you had a problem employee and you were performance managing them and you were going to terminate them, and then all of a sudden there's organizing going on, you can still go ahead with that termination so long as you can show that this is business as usual, this would have happened regardless, had nothing to do with the fact that the union's organizing. But if that decision is tainted in any way and it's found you didn't have proper cause, then that could be an unfair labor practice too, and you could have the union arguing that that's automatic certification. Section 9 of the code prohibits coercion or intimidation. So this applies both to the employer and the union. Any behavior that might affect someone's ability to independently choose whether or not to support the union would be a breach of Section 9. So some examples, the supervisor telling the employees that the plant or the restaurant's going to be closed and moved out of the country if the union comes in, asking the employees if they've signed union membership cards is considered a breach of Section 9. Holding a mandatory meeting and telling all the employees that the union's bad and it's going to have a negative impact, that would be offside. And telling the employees that they're not going to get a wage increase because of the union potentially could be offside. All of that stuff is dangerous territory.
Chris, we could do a whole day webinar on what constitutes an unfair labor practice, et cetera. So we can't do that. But again, we're just trying to alert people to the fact these are the things that could come up. And so if you're prepared for it, you can at least communicate with your professional advisor in very short order as to what the defenses may be, et cetera, et cetera. The other thing that I want to remind everybody is that, the labor code is tilted in favor of unions. And one of the areas is that if you terminate somebody, there's a reverse onus on you under Section 14 that you've got to prove that none of the that your decision was not tainted. So all of these things come to play to make it difficult if, in fact, you react or overreact to the union's application for certification. And so much of what Chris and I talk about, because usually the game's over by the time you get the notice, we focus more on areas that Chris and I'll talk about later about who's in, who's out. But as Chris will talk about, the remedial certification is significant, and it's something you have to bear in mind.
Yeah, exactly. So Section 8 of the code deals with employer free speech, and that's another section that's kind of gone back and forth with the political winds. But it's still in there, and it's still a viable defense for the employer to communicate to an employee a statement of fact or opinion reasonably held with respect to the employer's business. And so what that means is oftentimes in organizing campaigns, we'll see union propaganda floating around about how great it is to join the union. And sometimes that propaganda will actually disparage the business, or it will make an untrue statement about the business that's being organized. The employer still has the right under Section 8 of the code to communicate a true factual statement about the employer's business. So, maybe the flyer says, the employer's benefits are terrible because they don't have this. Well, you can do a correction and tell the employees that absolutely our benefits contain this. Those are the types of things, those neutral, factual statements that can be made that don't go offside of Section 6 or Section 9. So again, all of this stuff is tricky, knowing what to say and what not to say, and staying out of hot water as far as the unfair labor practices. The flip side of the unfair labor practice coin is the remedial certification, as I mentioned. There's a list of cases there in the slides, which you can review on your own time. But essentially, the theme of those cases is the employer either acted with a real anti-union animus in the way that they dealt with the organizing campaign, and or they terminated the employment of either union organizers or people that were in support of the union. And so in those cases, the labor board said that those terminations were unfair labor practices and remedial certification was ordered, notwithstanding the results of the union cards. And this can be really extreme, like the waste control saga is particularly interesting. In that case, Mike, and correct me if I'm wrong, is that the one where the union had only signed up 2?
No, that's a little different. That's I think the West Bin. In the West Bin, they signed up 2 out of 90, right. And the employer fired the one of the 2, I think. And so that's how crazy extreme Chris is talking about.
Yeah. So only 2 of 90 supported the union. One of those 2 was fired. Was determined to be an unfair labor practice, and the entire 90 were certified. So you can have a really significant result there that could have been avoided if the employer had been a little more restrained.
Yeah, and we've included the waste control. If you want to have a saga of what not to do, you may want to read that series of cases. It starts off with serious unfair labor practices with the union organizing, but the union didn't get remedial certification. So the employer kept on pushing the envelope, and guess what? They got remedial certification. Then they went into collective bargaining, and there were more unfair labor practices as the employer started pushing the union negotiators around. Finally, and this is the end of the story that's bizarre, is that in an application to decertify, it was found that no, we're not going to allow the employees to decertify. because of all of the action. So it's kind of your worst case scenario. It's where becoming unionized can often be like crazy glue. It's a little hard to move things around. So again, you've got to decide, do you want to be a deer in front of the headlights and do nothing, or do you want to be proactive? In the absence of a secret valid vote, Chris and I tend to try to focus on the other areas where you may be successful.
Great. Over to you, Mike.
So I kind of mentioned at the beginning, Stan Lanyon gave us the gift of IML case. And it was a case that the new labor board in '92 said, this is how we're going to approach certifications. First of all, where the union's application membership does not mean automatic certification. They have to prove some things. And one of the things they have to prove is that they're applying for an appropriate bargaining unit. It doesn't have to be the most appropriate. The most appropriate would be all of the employees at the McDonald's restaurant at XYZ place. I mean, that would be, except those excluded by the code. But the labor board says, no, it just has to be an appropriate bargaining unit. So understanding that concept going into the hearing or well in advance may assist you. Is the bargaining unit applied for appropriate for collective bargaining? And the keystone out of IML is that they look at the community of interest for determining whether or not the unit's appropriate. Two fundamental purposes for determining appropriateness is this. Number one, access to collective bargaining. How easy is it for employees to get unionized? And number two is industrial stability. Now, both of those elements are always there, but on an initial application for certification, and what creates a real problem for employers is that the primary, and I will suggest only, concern is access to collective bargaining. And so it's only in the second application, if another union comes along or they want to get another group of people in that weren't in the initial one, that's when industrial stability comes in. So it's not. So what does this mean? It's a building block approach, right? You get a corner of a group, and then the union starts to build from there, and they keep adding and adding as they then get a toehold. The union on a first application must show that it has a rational and defensible boundary around it. And what community of interest means under IML are these four kind of critical concepts. First of all, similarity in skills, interests, duties, and working conditions. Now, what's again shows the labor board trying to support unions more than they perhaps used to is that there's a recent case that talks about, well, in the world, the real world, the similarity of skills and interests and duties are going to be different. So we're not going to give as much interest to that as possible, okay, or much weight. The physical and administrative structure of the employer, if it's one that kind of breaks down the ability for the union to argue defensible grounds, that will assist. The big one I'm going to talk a little bit about is functional integration, and then geography. So if they're totally separate operations and people geographically separated, that may be a significant factor. So we can't go through all the ins and outs of this, but this is the critical test. Is the unit applied for functionally integrated with another group of employees? And what's important is the labor board says, look, in IML, a functional relationship between departments is to be expected in a workplace in order to operate, right? This is especially true in today's workplaces. Competing in a global economy has resulted in employers and employees becoming increasingly concerned with productivity issues and better management of employees. A strong functional relationship between departments to ensure a smooth running, efficient workplace is common. So we're all excited saying, good, that's functional integration, no problemo, we'll be able to defeat most union applications. Wrong. Functional integration is different than functional relationships. And so it's the former that you have to establish in order to defeat it. Functional integration refers to the employee interchange, shared duties, integrated job duties, overlapping duties, team processes, continual work processes. So not all levels of functional integration will result in a determination that the bargaining unit is inappropriate. The board will examine the nature, type, and extent of functional integration to determine whether the proposed bargaining unit structure will result in a viable collective bargaining, given the principle of the importance of collective bargaining, i.e. the importance, according to the Labor Relations Board, of how important it is for employees to be unionized. I should say, most of the applications we see, for example, will say all employees except office and sales. The office and sales exemption or being exempted from the certification is quite often, doesn't have to happen. But generally, if there's going to be groups excluded, it's because the union wants to get a toehold and they want to say it's not the most appropriate, but it is an appropriate one. So that's the reason. Okay, so here's some things that Chris and I will talk about if we get the opportunity on your behalf at the hearing. So you can imagine how fast we have to move on it. But these are functions of whether
I think we lost Mike here. We should get him back in a minute or two. If not, I'll carry on. Hang tight, people. Mike, you there? Okay, I'll carry on here and Mike can pick it up when he, oh, there we go. There we go.
Oh, can you hear me? Yeah,
Yep.
I'm sorry, I'm going in and out. That's, what can I say? Don't use TELUS. Anyways, so see, these are the things that we raise because it may change the numbers dramatically. Part-time and casual employees. We've given you some case. Edico Heatley is the leading case. So if they're completely casual without much connection, they're not going to be, we can get the casuals excluded. Or quite often, we want to include them because the union likely doesn't know about them. Part-time employees are going to be generally included. One of the points I want to make, and I noticed that I act for a lot of credit unions, for example, and back when they didn't have as many ATMs and stuff, they had a lot of frontline staff, tellers, and many of them were part-time. And many of the money management people behind the scenes were full-time. Trouble is, part-times get one vote, full-time gets one vote. And so in structuring your business, and this may be particularly apropos for your business as a fast food or a small retailer, you may have part-timers that the union may not know about. And so it's just one of those interesting things. But clearly, Chris and I will talk about that. Managerial exclusions. And the labor code itself says, look, people who are clearly managers, as they define it, or are employed in a confidential capacity related to information, will be excluded. They are not employees for the purposes of the labor code, right? And so, you know, if all the managers are included in the bargaining unit, it's like clapping with one hand. The system doesn't work. And so it's because of that that the labor board says and the government says, no, we've got to have people on the employer side whose undivided loyalty to the employer is not compromised by them being in the union. But it's a very narrow definition of who's a manager. And we'd have to, you know, they have to have the three critical items is they have to be the effective determination on discipline and discharge, labor relations input, which is very broad, and hiring, promotion, and demotion. So those are questions we would ask you know, on a particular individual. Is that person in or out? The union may say the person's in. We'd say, no, they're out for these reasons, or vice versa. Managerial exclusion, Sums Groceries. There's another case called Bon Macron that I'll talk about. Like, I had 10 employees in the bargaining unit, but yet these issues were being fought over. So it's not just the size of your organization that creates these problems and these issues. Okay, a couple of other things that I haven't noted on the slides that I will note. For example, you may have somebody that you say is an independent contractor, and the labor board may say, no, he or she is actually an employee. We see this a lot in the car dealers area, where sales managers are known as independent contractors. Well, they're not. They're employees. It's the old, if you waddle like a duck and quack like a duck, you're a duck. So if, in fact, somebody you're calling a contractor is an employee, they're going to be included. And there's some cases on that. I know that Starbucks keeps talking about people being their partners. Well, that's not a legal distinction because they're all employees. There've been old cases, the McDonald's case up at Squamish in the 90s, about whether or not people, because they had students who were under 15 or 16, I think, whether or not they were eligible to vote. And then there's another one called the build-up principle. And this would be applicable if you were starting a new restaurant and or a new outlet and just started to gear up. And the union comes in and signs up, 10 employees, but you're going to have 50. You may be able to say, hang on, that's a premature application. So it's a buildup. So all of these things, again, get to play based on the particular facts of the case. Confidential exclusions, I mentioned. They have to have, somebody has to have regular and substantial access to and judgment being made in relationship to confidential information. So again, supervisors, et cetera, that may have access to confidential information are not necessarily excluded. Employees on sick leave and LTD. I acted for Aldo many years ago. True story. We had some people that the union was shocked to find were still with us on LTD and sick leave, and we were able to defeat the application. If there's no reasonable likelihood of somebody on LTD coming back to work, they're going to be excluded. The length of time away is definitive. So those are factual things that we've got to decide, because whether or not two people on LTD and one on sick leave, if they're not likely signed up by the union, those three people in your small organization may at least tip an automatic certification into a vote, and then we're off to the races, okay? Familial employees. Now, this always breaks me up. On one hand, we got the Human Rights Code, and they've just had some leading cases that make discrimination on the basis of family status a real serious problem for you. And yet the Labor Code and the Labor Board says, well, sometimes we shouldn't allow the husband in, or the children shouldn't be allowed to be part of the bargaining unit. And so to me, there has to be kind of an actual, it's a potential conflict, not the actual conflict. So again, those are issues that come up. Work permit employees. I thought I'd mention this case because I'm not sure how you people on this call are manning their operations. But if you're using people on work permit employees, et cetera, this Bon Macron case where they went to appeal, first of all, I noted there were only 10 people in the unit. But in any event, the employees who are on an open work permit were found to have a continuing interest in the application. Basically, if an employee is working on the date of the application, there is a very strong presumption they are employees, right? But you'll get some examples. For example, in a case called Surtec, we were able to exclude some employees who had given formal written notice of resignation shortly after the application was filed. effective shortly after. That was enough, but that's an exceptional circumstance. Employees are laid off. They have to have a sufficient continuing interest in the unit. And so sometimes we argue under the Employment Standards Act, an employee under the Employment Standards Act, if you're laid off for 13 weeks within a period of 20, you are considered terminated. That may be a function of it. Employees on leave, on call, WCB, mat leave. We all know mat leave is going to likely have the person included. As long as they have a continuing interest, if there's a return to work date, that makes it clear. Employees that are on call, as long as they show some regularity in employment, will likely be included. Employees on WorkSafe, WCB, Chris pointed out to me, Chris is our guru of WorkSafe issues, pointed out to me some amendments that now kind of mirror the Human Rights Code, where you've got to look at taking employees back to work if they're on WCB. So all of those things would come into saying, look, do these people have a sufficient continuing interest such that they should have a right to vote or be their card signed up? That's the question being asked. One unfair labor practice that we didn't talk about that I just thought of, there is one that employers can use, and that is Section 7. Unions cannot organize employees on company premises on company time. So in the lunchroom they can, but they can't do it on company time. And so sometimes it's been pretty obvious the union has been interrupting work by doing actual organizing on company time. So that's something we often raise. You don't get very far, but it's just another something we can raise as an issue. Okay, Section 142. So let's assume you've got a fast food outlet in Langley, and you want to, the union gets certified for that, and then it signs up people in your Surrey operation. The union may apply for a separate certification for Surrey. So you've got two certifications, two duties to bargain, two yada yada. Or they may say, we want to vary the certification we have in Surrey or in Langley to include the certification in Surrey. So we have one bargaining unit, but two operations. Or they may just initially apply. And I gave you some examples of how that works. Starbucks had a Surrey Starbucks, and they had a Langley outlet, and they were certified under 142. I know I was attending another matter at the Labor Board, and at the same time, an application for certifying, I think it's the Powell River Starbucks, was before the board. And the union was arguing
Mike, we lost you again. Just give us a minute, everyone. Mike, you with us? Okay. I will pick it up, and Mike can come back in once he gets back in. So yeah, the slide kind of outlines a couple examples there where the union used the certification, the initial certification at one store to expand the bargaining unit by kind of adding on additional stores. There we go.
Am I back
Mike?
on?
Yeah, you're back. Yeah.
Yo. Yeah, so let me just finish this part, Chris, then. So again, it's an application that you may find yourself in if you've got a number of outlets that we'd look at the particular facts of the case. where also 142 becomes, so let's assume you've got the 2 units, right? Like the Grounds for Coffee Company they had the Alma store and they had the one on Commercial, and the both of them had been part of a certification. So the people at Alma said, we don't want to be part of this. So they applied for decertification. They couldn't apply under Section 33 because they weren't going to decertify.
Oh, we lost him again. We lost you again, Mike. I think we'll have to take over here. So let me pick it up on the next slide. I will talk briefly about a case here on what can go wrong in terms of when you have a union organizer and you terminate them. The Starbucks case was decided this year, and this case is part of an ongoing saga relating to the unionization efforts for Starbucks in BC. Mike, I'm just picking up with the Starbucks here.
Okay.
So in this case, the Starbucks location on Dunbar in Vancouver was certified in February of last year. Starbucks then closed that store about 6 months later in September and transferred out all of the employees to other non-union locations. The union filed an unfair labor practice relating to the closing of the store, but that wasn't dealt with in this case. That was put off to another day. The decision in this case concerned an employee, Miss Martineau, who was identified as the lead organizer, basically the one that brought the union to the Dunbar store. So after the closing, she ended up getting transferred out to the McDonald's store, which was the one on McDonald Street. But she was terminated about a month later after Starbucks said she violated Starbucks policy by using profanity in the front of the house. The union's complaint in this case was essentially that Ms. Martineau was mistreated by Starbucks and ultimately terminated because she was known as the union organizer. So Starbucks was motivated by this anti-union animus. And for that reason, Starbucks had committed an unfair labor practice. There was an expedited 6-day hearing to determine whether Starbucks had committed an unfair labor practice by doing this dismissal. And the crux of the 6-day hearing was to determine, did Starbucks have a credible explanation for dismissing her, or was it tainted, or was the real reason the anti-union sentiments they had against her? So what had happened is, shortly after she got transferred to the McDonald location, Miss Martineau's co-workers reported that she was swearing. So she was saying things like, "Get off my effing floor if you're not going to help me." She would, when customers were there, she would say, "Starbucks effed over the staff by closing the Dunbar store. Starbucks effed us over," that kind of stuff. And so the store manager followed corporate policy and took these complaints up the chain to someone called a partner representative, who worked out of Calgary and handled all of the discipline and termination matters for Starbucks. So under the guidance of this corporate process, the manager conducted an investigation, took statements from the co-workers, had witnessed this profanity, and interviewed Ms. Martineau. Ms. Martineau had denied that she swore, and ultimately the store concluded that the statements of the co-workers were more credible. So Starbucks had a very clear policy that profanity being used in the front of house, either to employees or in front of customers, was not to be tolerated and could result in termination for cause. There was past examples of employees being terminated for swearing, and other employees at the store, they all testified that they knew that if they swore around customers, they could be fired. So over the 6-day hearing, there was evidence from all different people about Starbucks's corporate procedures and what the employees heard and what the employees understood, and all kinds of circumstantial evidence came in. And based on all of this, the labor board basically said, we agree that Starbucks had a credible business reason for terminating Ms. Martineau, strictly for violating its swearing policy. Regardless of the fact that she was known as the organizer, the decision wasn't tainted by anti-union animus. And so after the 6-day hearing and tens of thousands of dollars in legal fees, the union's application was dismissed, and they're going on to fight the next battle in terms of the store being closed and some other matters that were raised. So, certainly Starbucks has the advantage of having this massive corporate structure, having robust HR processes in place, and specialized HR professionals that can help guide you through these things, and very clear processes and all that. Not all of you will have that same access to a corporate backdrop. For those that are franchisees, sometimes the franchisor will provide some HR support, but oftentimes they don't want, they're not the employer. They make a point of not being the employer. They don't get involved in individual store matters. So it's all the more reason to have good HR policies and procedures in place for common things that come up, like respectful workplace, investigation of harassment complaints, all of that kind of stuff. Having a really good, solid, defensible policy system can allow you to point to those policies and rely on those policies to give a credible business explanation if you have to terminate someone and the union argues that it was anti-union animus.
Am I back on, Chris?
You are back on.
Good. Okay, well, I'm going to go as long as I can until Telus gives me the hook. So let's move on to a general area that Chris and I like to talk about is, okay, so Mike, this is all well and good, but what do we do today to avoid the possibility or minimize the likelihood of unions being in our shop? And I think the first thing, and I've been doing this for a long time, is the first thing I would do if I ran a business and was worried about whether employees are unionized, probably in the morning after I get out of the shower, probably the most honest all day I'll be. And I say, if I work for me, why would I join a union? Right? And it would just have that hands-on common sense that I hope all of you have, because all of you seem to have, if you're not unionized, you're doing the right thing. I'd suggest get rid of the garbage can under the suggestion box. You can't agree with all the employees, but if they don't think you're listening to any suggestions, then they may look for an alternative, which would be a union. We can talk about what causes employees to be unionized. I've had extreme examples of where up north in a broadcasting thing in Terrace, the second in command would drive in with his Corvette Stingray and get the parking spot right next to the building with the plug-in, and the rest of the people had to park their cars far down the road and didn't have plug-ins. And it gets cold up there. So those are the kind of things that are hard to understand. The big thing I would suggest to make sure you comply with the various statutes. Employment Standards Act. Chris has had some experience recently where it can be a real problem for employers because you unintentionally don't follow the Employment Standards Act. If you're doing it right, then those don't create avenues of discontent among the employees. Educate your supervisors and managers. Make sure they don't put their foot in your mouth. Listen and watch for signs of organizing. A little harder now with this electronic organizing that they're getting, but keep the emails confidential so that they can't get access to it. And take a look for brochures. We've had occasions where unions have put out brochures that are simply wrong. You don't have this, you don't have this. We go back and say, of course we've got this. So keep an eye open for that. Look for signs of organizing. You may find that you can get advice early. Check your benefit and compensation packages. I think Corey from Langley Chamber is on The chambers have really good plans for benefit. So if you don't have a benefit program, you may want to look at the various chambers plans for small business. You should all be members and actively involved in your chamber, if I may recommend. Check your competitors' collective agreements. You can go on the website and get them. So if somebody's got it, and just all you do is match what you think that the union may be selling. There's a great case with Starbucks over in Victoria, where Starbucks didn't give a raise to the non-union, didn't give a raise to the unionized employees, but gave a raise to the non-union. And in that case, you can see how the union was what they had in their collective agreement, which was helpful for the employer. Communicate both good and bad news. I mean, most employees just want to be treated fairly. They can understand if it's bad news most of the time. Employee committees, I think some of them are required under various legislation like WorkSafe, but also use them and update the material you may need. Example, employee lists, again, all part and parcel of what you may want to do there. And so, Chris, am I still on?
Yep.
So the next, and these are just interesting things. As I noted, the unions strike quickly and strike fast. So you have to have like everything, an emergency list. If senior management are out of town, the next in line has to be ready to make the contact and prepare. Have written employment contracts are available to you for the proper cause issues. Chris mentioned the policy manuals that are important, again, to establish proper cause, and also policy manuals. Don't have like a 200-page one and put it in your top drawer and nobody looks at it. It's got to be a living document. Either it makes sense and employees appreciate it or understand it, or it doesn't. I recommend that you have it make sense. Hiring skills. Chris and I do a webinar on the art of hiring. It's the most important part of your business and the most neglected. So that's an area you got to be careful about when you're hiring. Listen to that little guy on your shoulder. Maybe this isn't somebody we need. Be careful if you're buying a restaurant or a franchise. You may be buying a pig in a poke if a union is organizing. The best advice is get your information ready if the union applies and see what happens, what arguments can be made. And keep phone numbers and contact information available on your emergency list. You can put Chris's phone number and email and mine, or whoever, law firm that you use. Just make sure that the lawyers know what they're doing, because there is not time within that 5-day period for training wheels on the lawyer that is advising you. And we've had a couple of cases where clearly the lawyers attending the hearing didn't know what potential arguments could be made. Okay, I'm going to end up with, if I can, just got about 10 minutes left. So under the Labor Code, Section 3, the government must have a new panel struck to consider whether or not the Labor Code has to be changed again every 5 years. And so now's the time in 2024. So they struck a panel without giving the business community much time to respond. Although, must say again, Corey from Langley, he was one of the chambers who responded, and that's really important to have that small business oar in the water. So they've been gathering submissions. They have 750 pages and counting. They've had many live application or interviews, and many proposals that the unions have made are really on the edges of some of them. In one case, they'd like to get rid of any managerial exclusion, like it's kind of crazy world. One of the ones that struck me that may be interesting, because if the NDP get back in, that may be what they do, is give the union, if they sign up 20%, a full list. It's not a certificate, but a full list of all the employees so they can make contact and see what they can do. Amazon recently beat the certification, in large part, I think, I don't know for sure, because they had, the union just didn't realize there were that many people in the bargaining unit. So that would be important to have that list. But the biggest concern I think you should consider is sectoral bargaining. In 92, the majority of that panel offered their view of what certification should be in the sector, including fast foods. And so we've included, I think, Chris, the material from the SEIU Local 2 submission that is stunning, because they're the small union, they organize small units. And one of the big ones they're going after are liquor stores, by the way. And there's a whole section they talk about there. But they say, look, because organizing is done on an enterprise basis, so it's the McDonald's restaurant, even if there are 6 of them in the group, that they got to go after. They just don't have the resources, especially given the nature of the workforce usually in those things. So they're saying, look, give us an opportunity to have a sector, in essence, that's certified. And what the SEIU, being realistic, has said, the first thing you do is have a committee set up and a commission, and they'll look at it, but come out with recommendations to put meat on the bones. But the bottom line is they want to be able to say, essentially, if we organize your operation, the employees are automatically covered by this master collective agreement. Or they may even go further and say, if you're working in a fast food at McDonald's in Langley, you are covered automatically, whether the employees want to or not. So that's the danger I see. I think it's less likely that the NDP would do it. They didn't do it in 92, but now they're more aggressive. So there's some more slides on that. So those are the general things that we think are important for you to consider. I mean, hopefully you never get that phone call, and hopefully all you do is send us a Christmas card. But it may be that on that Friday of the next long weekend, you may say, holy Lord, isn't this appropriate? I just got a phone call. Now, we're not going to send the union to organize you, but they may have their own desire to do so. We think that knowledge is power, as Francis Bacon said, and with knowledge, we think you can make these informed decisions to organize your place. You can quickly respond. So if you're dealing with your professional advisor 2 days before the hearing, you know what they're asking, why they're asking it. It makes it a lot easier to prepare any defenses. We strongly suggest that you sign up for our newsletter, our blogs. We keep you informed. We are trying to be cutting edge so that you find out about issues that come up and that you can maybe take steps to handle. Some employers that may want to look at this in greater depth. Many of our clients say, look, come on over, let's talk about as if they applied. What can we do and look at, and just further review. If you wanted us to do an audit of your work price, Chris or I could do that. So just get ready. As I say, operators, standing 724, give us a call if you need us. Chris, any questions that they have that we can answer in this short period of time?
Yeah, we've got a few more minutes, everyone. So if you have a question, feel free to either pop it in the chat or you can come on video and ask. Okay, I'm not seeing anything. Going once, going twice. Okay, no questions. So feel free. We'll send some follow-up. And if you have a question or want to talk about something in depth, don't hesitate to email Mike or I. Thank you, everyone, for taking the time to attend. We have recorded the session, and so if you want to distribute that, we'll send that over with our closing materials, and you can send that to your contacts and your managers and other people you think would benefit from the session. Good stuff. Okay, thanks, everyone.
Everybody.
Take care.